Hello everyone, welcome to another episode of this particular video, and by name I am Japhet Okaka Ebosetari. So for today, under law of tort, we are going to be looking at public nuisance and private nuisance. Initially, we have touched on the distinction between public nuisance and private nuisance, but for today we are going to take an in-depth look at public nuisance and private nuisance, and we'll also be looking at the categories of persons that can sue and be sued in public nuisance and private nuisance. So now let's begin with public nuisance. What is public nuisance? Now, a public nuisance is any conduct. A public nuisance is any conduct that interferes with the reasonable comfort and convenience of the public. A public nuisance is any conduct, it is any act that interferes with the reasonable comfort and convenience of the public. This means that there is an expected amount of comfort, there is an expected amount of convenience every member of the public is expected to enjoy. And by the time an act a particular conduct then interferes with the comfort and convenience that the members of the public are expected to enjoy, then you can refer that act as public nuisance. An example would be where Mr. A has a factory, and due to the activities of this factory, the air is contaminated. There is noise in the community due to the activity of this factory. Now, the members of the community are affected, the members of the public are affected. You can refer that act as public nuisance. It is not just that a single individual is affected due to this act, but a substantial amount of the members of the public is affected. Now, you must note that for public nuisance, it is not necessary that everybody in the community must be affected. For public nuisance, it is not necessary that everybody in the public, everybody in the community must be affected. No, by the time a good number of people in the public have been affected, then you can refer that act as public nuisance. Now, having said this, let's then move on to the examples of public nuisance. You can see some examples in section 234 of the Criminal Code. In section 234 of the Criminal Code, some examples of public nuisance were listed there. But let's take some examples of public nuisance. Now, the first example is obstructing a road and hindering right of passage or travel. Every member of the community, every member of the public has a right of passage, has a right to travel. Now, by the time Mr. A then takes his lorry, by the time Mr. A then takes his lorry and use his lorry to obstruct the right of passage, use his lorry to block the road, then you can refer that act as public nuisance. It is not only an individual that is obstructed from passing the highway, but a large amount and a good number of persons in the public have been obstructed. A good number of persons are now unable to pass the road. So that is an example of public nuisance. Another example is obstructing rights to fresh air. Every member of the public has a right to access fresh air. But however, when Mr. A's company, when due to the activities of Mr. A company, the air in the environment is now contaminated, now you can refer that to public nuisance. You can refer that as public nuisance. Why? It is not just an individual. It's not that an individual no longer have the right to access fresh air, but a good amount of individuals in the public can no longer breathe in fresh air. So that is an example of public nuisance. Now, we'll now go to another example, which is selling impure food or drink. Selling impure food or drink. So by the time a Mr. A, for example, sells impure food, sells impure drink that is dangerous to the body, you can refer that act as public nuisance, because that particular act does not just endanger only an individual, it endangers the general public, because anybody in the community can go to Mr. A, send me so and so. Then after eating it, the person becomes sick. So that act is public nuisance. So the act of selling impure food, the act of selling impure drink is public nuisance because it endangers the lives of members of the public. So it is referred to as public nuisance. Another example is play loud music. Play loud music. So by the time Mr. A plays loud music, so loud, and now the members of the public are disturbed. Certainly, it's not everybody that is disturbed, but due to the fact a substantial amount of persons in the public have been disturbed, then you can refer the act as public nuisance. Now, those and many more are examples of public nuisance. There are many examples of public nuisance, but the most important thing you must note is that by the time an act, by the time a conduct interferes with the reasonable comfort and convenience of the members of the public, you can refer that act as public nuisance. Now, we'll now move on to persons who may sue for public nuisance. Persons who may sue for public nuisance. This means that these are the individuals that are capable of instituting, that are capable of bringing an action in public nuisance. So now we are going to be looking at those categories and classes of individuals that can bring an action in public nuisance, that can institute an action in public nuisance. Now, the first category is the Attorney General. The Attorney General can institute an action in public nuisance. Now, you must note that it is the state that persecutes crime, and public nuisance is a crime. Private nuisance is not a crime, but public nuisance is a crime. And due to the fact that public nuisance is a crime, it is the Attorney General that is empowered by the Constitution to institute an action for public nuisance, because it is a crime and it's a conduct that is against the state. Now, another category of persons that can institute an action is the police, where a public nuisance is a minor offense. You see it, where a public nuisance is a minor offense, the police may arrest, charge, and persecute the tortfeasor or alleged offender in the magistrate court. So, by the time a nuisance is not a serious offense, but just a minor offense, the police can bring and can institute an action against the alleged offender. So we have listed two categories so far. We have stated the Attorney General can institute an action, the police can bring an action, and also for public nuisance, a private individual can institute an action. A private individual can also institute an action for public nuisance. But for a private individual to institute an action for public nuisance, he must be able to prove particular damage. He must be able to prove particular damage. Let's go on. A private individual may sue a tortfeasor provided the private individual can show that he has suffered special or particular damage over and above the general public. So for a private individual to bring an action in public nuisance, for a private individual to bring an action in public nuisance, he must be able to show, he must be able to prove that he has suffered specific, particular damage over and above the general public. If this is the only instance a private individual can bring an action, he must be able to show that he has suffered specific, particular damage. Now you'll be like, what is particular damage? From the word particular, you can see that it simply says special damage. It simply says something peculiar to the private individual. For example, when Mr. A factory, where due to the activities of Mr. A factory, there is loud noise in the community, and due to the loud noise in the community, Mr. B got deaf. Now, the members of the public have been interfered with. The members of the public are disturbed by the noise, but Mr. B got deaf. Mr. B got deaf. Now, that is particular to Mr. B. That is particular to Mr. B. Yes, the Attorney General can bring an action, but Mr. B can still bring an action due to the fact that he suffered particular damage, due to the fact that his damage was peculiar. The rest members of the public were only disturbed by the noise, but his damage was peculiar. He became deaf. He became deaf due to the noise. So, in that particular instance, Mr. B can institute an action. Now, those are the three categories of person that can institute an action in public nuisance: the Attorney General, the police, and private individual, in as far they are able to show that they suffered particular damage. Now, let's then look at elements of public nuisance. Elements of public nuisance. The elements of public nuisance simply says that for you to sustain an action in public nuisance, these are the contents that must be present. For you to succeed in public nuisance, these are the things that you must prove. These are the factors that must be present. These are the ingredients and spices that must be present for your action to succeed in public nuisance. Now, the first element of public nuisance is that the nuisance is material. The first element for public nuisance is that the nuisance is material. The nuisance must be material. The nuisance must be real. It must affect the comfort of the people. The question of materiality or realness of nuisance is subjective and is a question of fact of each case. So, for an action to succeed in nuisance, it must be material. It must be substantial. It must not be something that is trivial or something that is so minor, something that everybody can just accept or adopt to it. So it must be material. It must affect it must affect the comfort. It must affect the convenience of the members of the public. It must affect that comfort that was expected, that the public are expected to enjoy. Just the way I gave an example of fresh air. Every member of the public is expected to have access to fresh air. Now, by the time it is obstructed, by the time the air is contaminated, then that is public nuisance. It is material enough. So the first element for public nuisance is that the nuisance must be material. It must be substantial. It must be real. It must not be trivial or minor. Then we'll now move on to the next element of public nuisance, which is that the nuisance is interfering with the ordinary comfort or causing inconvenience. Now, the nuisance must cause inconvenience. The nuisance must interfere with the ordinary comfort of the members of the public. Let me illustrate this. For example, if Mr. A parks his vehicle somewhere, but it is not interfere with anybody's right. It is not interfering. Yes, the vehicle was not properly parked. Yes, the vehicle that Mr. A parked was not properly parked, but it does not interfere with anybody's right to passage. It does not interfere with anybody's right. It does not cause inconvenience to anybody. Then that is not public nuisance. So, for an action to succeed in public nuisance, it must interfere with the people. It must interfere with the rights of the people. This is the second element of public nuisance. Then, this then brings us to the case of Ejohumu versus Edok Eda Mandilas. Ejohumu versus Edok Eda Mandilas. Let's look at this particular case. Now, in this particular case, the defendant company wrongfully blocked a public highway, thereby barring access to the plaintiff poultry farm and resulting to business losses of the plaintiff. The defendant wrongfully obstructed the highway, and due to the fact the defendant obstructed the highway, the plaintiff could not access his poultry farm, and this resulted to economic losses. Now, what did the court say? The court held that the plaintiff was entitled to recover for the public nuisance because because the injury he suffered was beyond the general inconvenience and injury suffered by the public. So for an action to succeed in public nuisance, it must cause inconvenience, it must be material, and it must cause inconvenience. By the time it is not material, it is not substantial, and it does not cause any inconvenience, that action cannot succeed in public nuisance. These are the elements of public nuisance. Now, before going to private nuisance, let's then look at the case of Enwachukwu versus Ebuchu. Enwachukwu versus Ebuchu. Now, in this particular case, the defendant appellant blocked a street. The defendant appellant blocked a street, thereby depriving the plaintiff respondent and other neighbors to use the road. The defendant blocked a street, and due to the fact he blocked the street, the plaintiff and other neighbors could not pass the road. They could not pass, they could not access the road. Now, what did the court heard? The court heard that the defendant was liable to public nuisance. That was the decision of the court. Now, we have dealt on public nuisance, we have dealt on the examples of public nuisance, we have given the elements, the ingredients that must be present for an action to succeed in public nuisance. Now, let's then move on to private nuisance and look at the elements of private nuisance. Now, what is private nuisance? A private nuisance is any continuous and unreasonable interference with a person's use of his land, comfort, health, convenience, or property. A private nuisance is any continuous. So you must note that word continuous. You must note that word continuous. A private nuisance is any continuous and unreasonable interference with a person's. Now, when we're dealing on public nuisance, it was like a conduct or act that interferes with the rights of the public. But now, look at private nuisance. They say that it is written, it is any continuous and unreasonable interference with a person's, none other the public. It is no longer the public, but a person's use of his land. It is now a person's use of his land. So for private nuisance, that act must be continuous and it must interfere with a person's rights. It must interfere with a person's comfort. It must interfere with a person's rights to use his land. So that is private nuisance. It does not affect the general public, but it must affect a person's rights. Now, generally, a private nuisance is any unreasonable use by a person of his land or property to the detriment of his neighbor. To the detriment of his neighbor. Not to the detriment of the members of the public, but to the detriment of his neighbor. That is another definition of private nuisance. Now, let's then look at the elements of private nuisance. We have dwelt on the element of public nuisance. Now, let's now look at the elements, the ingredients of private nuisance, the elements, the factors that must be present for action in private nuisance to succeed. Now, the first element of private nuisance is that it must be a continuous interference. There must be a continuous interference. So, for private nuisance to succeed, there must be a continuous interference. It must not be a one-time act. It must not be a one-time act. It must be continuous. It must be continuous. And due to the fact that it is continuous, it makes it material. Due to the fact that this particular act is continuous, it makes it material. It makes it substantial. Let's take an example of, for example, let's take an example of private nuisance, which is Mr. A has a poultry farm. Yes, Mr. A has a chicken, and due to the fact that this chicken makes noise early in the morning, Mr. B's comfort is being interfered with. Mr. B is being interfered with. Mr. B can no longer sleep well in the night due to the fact that Mr. A has chicken. Now, if this chicken just make noise just for one particular day, The next day is Christmas, and this chicken is going to be killed during Christmas, and this chicken was brought a day to Christmas. Now, the court will be like, it's just one time, it's just a one-time thing. It's just a one-time act. This chicken is going to be killed tomorrow. It's just going to be killed. It's going to be killed on the day of Christmas, and this chicken was brought a day to Christmas. The court will look at it as, no, it's not continuous. It's not something material enough. So in that particular instance, you see that that action will not succeed because it's not continuous. But when Mr. A has a lot of chicken, and in fact, he's farming this chicken, he's not willing to, or there's no time limit in which these chicken are going to be sold or killed. Now, in this particular instance, you see that it is a continuous act. Now, these particular elements have been proven. So, for private nuisance, the act must be continuous. It must be continuous. It must not be a one-time thing or a one-time scenario. Then, we'll now move on to the case of Bradford versus Turney. Bradford versus Turney, where Judge Bradway defined private nuisance as any continuous activity or state of affair. Judge Bradway defined private nuisance as any continuous, so it must be continuous, as any continuous activity or state of affair causing a substantial, now it must be material, causing a substantial and unreasonable interference with a claimant's land or his use or enjoyment of that land. So for private nuisance, one of the elements is that it must be continuous. Then we'll now move on to the next element of private nuisance. Which is that the interference or nuisance is unreasonable. That the interference or nuisance is unreasonable. It must not be reasonable. It must not be reasonable. It must be an unreasonable interference. The court will look at the fact of the case and try to see whether or not the interference is reasonable or it is unreasonable. Now, just like the particular example I gave where Mr. A owned a chicken, and it was going to be killed, it was brought a day to Christmas and it was going to be killed on Christmas Day. Now the court will look at that particular case. Is it a reasonable interference? Yes, this chicken made noise in the morning, early in the morning, but it's going to just be killed just a day on Christmas Day. So it's going to be killed on Christmas Day. So the court will look at the fact of the case to check whether or not that particular act is reasonable. So for an action to succeed in private nuisance, it must be continuous and the interference must be unreasonable. Then we'll now move on to the next subtopic under private nuisance. So we'll now move on to the next subtopic under private nuisance, which is classes of acts which amounts to private nuisance. We're in categories of acts, categories of private nuisance. So we are now in categories of private nuisance. So for private nuisance is divided into three categories. Private nuisance is divided into three categories. So anytime you are alleging that a private nuisance has been committed, it must fall under either of these three categories. Now, what are the three categories? The first category is physical injury to the property. So by the time a nuisance has been committed and there is physical injury to property or your property has been damaged, so on and so forth, then it falls under the category of physical injury to property. So physical injury to property is one of the categories of private nuisance. Now, the next category of private nuisance is interference with the use and enjoyment of land. Interference with the use and enjoyment of land. So by the time an action is brought for private nuisance, you have to look at what category does this particular nuisance you are alleging falls under. Yes, you are alleging that private nuisance has been committed, but you can try to categorize this particular private nuisance. which category does this particular act falls under. So by the time there is an interference with the use and enjoyment of land, then that falls under the second category of interference with the use and enjoyment of land. It's another category of private nuisance. The first category we dealt on was physical injury to property, which is not necessary to prove, but that's the first category. The second category is interference with the use and enjoyment of land. Now, the third category is interference with easements and profits. Interference with easements and profits. For example, if due to the fact Mr. A company, okay, let's give an example. Due to the fact Mr. A has a particular oil company, and due to the activities of this company, the soil have been contaminated, and the crops in Mr. B's farm were not able to do well. So it falls under this third category, which is interference with easement and public. Interference with easement and public. So where a nuisance consists of an encroachment or any form of trespass to land, the law will presume damage in favor of the plaintiff. So these are the three categories of private nuisance. The first is physical injury to property. The second is interference with the use and enjoyment of land. The third is interference with easement and profits. The profit you ought to make have been reduced, so that falls under this particular third category. So private nuisance is divided into these three categories. So after this, we will now go to persons that can institute an action in private nuisance. We have dwelt on public nuisance, we have dwelt on examples of public nuisance, and also you remember that we dwelt on persons that can institute an action in public nuisance. But now we are going to look at the persons that can institute an action in private nuisance, the person that can sue in private nuisance. Now, the categories of persons that can sue is anyone who has or uses a land or has an interest in land. Anyone who has or uses a land or has an interest in land. So by the time Mr. A has a particular land and there a nuisance have been committed, Mr. A, due to the fact he is the owner of the land, due to the fact he uses the land, he can bring an action for nuisance. So that is a particular category of persons that can sue or that can institute an action in private nuisance. Anyone who has or uses a land or has an interest in that particular land. Now, let's then look at the next categories of persons that can institute an action in private nuisance. And this is an occupier or user of the land. An occupier or user of the land. Due to the fact that Mr. A occupies this particular land, he can institute an action anytime nuisance have been committed, anytime private nuisance have been committed, due to the fact he is the owner of the land, due to the fact he occupies the land, due to the fact he uses the land, due to the fact he has the land, he has the right to institute an action for private nuisance. So these are the categories of persons that can institute an action for private nuisance. So you should not confuse the categories of persons that can institute an action in public nuisance for private nuisance. For public nuisance, it is the Attorney General, the police, and private individual, as far as they are able to prove particular damages. For private nuisance, on the other hand, it is anyone who has or uses the land, anyone who has an interest in the land, and also anyone who occupies the land that can institute an action for private nuisance. Now, we'll then move on to the next one, which is person who may be sued for nuisance. Now, we have dwelt on persons that can sue for public nuisance and private nuisance. But now, we are now looking at persons that can be sued. Not persons that can sue, but persons that can be sued. Persons that can be sued in court. So these are the categories of persons that can be sued for public nuisance or private nuisance. These are the categories of persons that can be sued in nuisance, whether or not it is public nuisance or private nuisance. These are the categories of persons that can be sued for nuisance, whether or not it is public or private nuisance. Now, let's look at the category. The first category is the creator of the nuisance. The creator of the nuisance. I think that's simple to understand. This simply means the person or the company that creates the nuisance. For example, like the example I gave of a company going on. Now, is this company that is going on? Is this company that is contaminating the air? Is this company that is making the noise? So, is this company that is the creator of the nuisance? The creator of the nuisance simply means the person or the company that creates the nuisance, that causes the nuisance. So that particular person or company can be sued for nuisance. Why? Due to the fact he is the creator, due to the fact it is the creator of the nuisance. So that's the first categories of persons that can sue for nuisance, whether or not it is public or private. Then we'll now move on to the next category of persons that can sue for nuisance, that can be sued for nuisance. Now, it is an employer. The employer of the servant who committed the nuisance on the ground of his vicarious liability can be sued. Due to, you will remember this Latin maxim, which is Q facit per annum, facit per se, which means that he who acts through another acts for himself. By the time the employer of this particular company tells his servant or gives his servant the authority to carry on a particular nuisance, the employer can be sued for that particular nuisance, even though it's not the one that used his hand to cause the nuisance, but he can be sued for that particular nuisance. Why? Because he gave the authority, because he instructed, or because his servant acted under his authority and then created the nuisance. So the employer can be sued for nuisance where he authorized his employee or his servant to commit the nuisance. So that is another categories of persons that can be sued, for nuisance. Then we'll now move on to the next categories of person, which is a landlord. This is the third category, and it is a landlord. A landlord or any person in possession of land may be liable for nuisance if he, so a landlord can be sued for nuisance in these particular instances I'm going to be listing. So in these instances I'm going to be listing, a landlord can be liable to be sued for nuisance. Now let's look at the instances in which a landlord can be sued for nuisance. Now the first instance is created the nuisance, whether or not he let out his premises. So by the time a landlord creates a particular nuisance, he can be sued for creating the nuisance. Now that's the first instance. Let's then look at the second instance. Expressly or implicitly authorized or ratified the nuisance. So by the time a landlord expressly or by implication authorize another person to commit nuisance, then that landlord can be sued for nuisance. This is the second instance. The first instance, he committed nuisance. The second instance in which a landlord can be sued is that he authorized another person. To commit the nuisance. He expressly or by necessary implication allowed or authorized another party to commit the nuisance. Then the landlord can also be sued for nuisance. Then let's look at the third instance in which a landlord can be sued for nuisance, and that is where he knew of the nuisance and allowed or permitted the state of affair to continue. So by the time a landlord know that somebody in his premises is committing nuisance and he does not do anything, he folds his hands and just keep on watching, then the landlord can be sued for nuisance. Then let's go to another instance in which a landlord can be sued if the property constitutes a nuisance. So by the time the property of this landlord, now the landlord is not creating nuisance. The landlord does not authorize anybody to commit a nuisance, but the property of the landlords is the property of the landlord constitutes a nuisance. The property of the landlord constitutes a nuisance, then the landlord can be sued for nuisance due to the fact that one of his property constitutes a nuisance. Then let's now go to another instance where he has a duty or is under a contract to repair and the nuisance arose from failure to repair. Where the property of the landlord is constitutes a nuisance, where the landlord has an obligation to repair something, and due to the fact that he has not repaired this particular thing, a nuisance has been committed. Due to the fact the landlord refused to repair something, a nuisance could be committed due to the fact he refused to repair that particular thing. Now, that the landlord can be sued for that particular instance because he refused to carry out his obligation. He was obligated to repair something and he didn't repair the thing. And now a nuisance have arose from that particular thing he refused to repair. Now in this particular instance, the landlord can be sued for nuisance. Now let's then move on to the fourth category of persons that can be sued for nuisance. The first one was the creator, the second was the employer, the third was the landlord. Now the fourth is an occupier. Yes, an occupier can bring an action for public nuisance. Also, an occupier can be sued for nuisance. An occupier can bring an action for private nuisance. An occupier can bring an action for private nuisance. And also, an occupier can be sued for nuisance as a whole. Now, an occupier or tenant of a property or premises may be sued if, so these are the instances in which an occupier can be sued for nuisance. These are the instances in which an occupier can be sued for nuisance. Now, the first is that he created the nuisance. So by the time an occupier creates a nuisance, he occupies the environment, he occupies the building, and then he creates a particular nuisance. The occupier can be sued for nuisance due to the fact he created the nuisance. Now, let's then look at another instance in which an occupier can be sued for nuisance. And it is he may be vicariously liable if his servant or agent created the nuisance while acting in the course of employment. So by the time the occupier, yes, he's the occupier, but he's not the one that created the nuisance, but his servant, his employee created the nuisance, then the occupier can be vicariously liable. Then we'll now go to the next instance where an occupier can be liable for nuisance, which is he engaged an independent contractor to commit the nuisance. Now he's not the one that committed the nuisance, but then he engaged an independent contractor to commit the nuisance. Then the occupier can be liable. This is why the Latin maxim of Q facit per alium facit per se simply says that he who acts through another acts for himself. The occupier contracted with met a private contractor to commit the nuisance, but he can also be sued for that nuisance, even though he's not the one that personally committed the nuisance. Now, let's go to another instance in which an occupier can be sued for nuisance. And it is if a third party, such as his licensing, guest, relation, or lodger, created the nuisance and he knew or ought to have known but failed to take measures to stop it. So by the time an occupier, then just for example, you own a particular lodge. Yes, you own a particular lodge or environment, and then your guest comes into your lodge and then starts committing nuisance. And then you know of this nuisance. It's not that you are not aware that this guest that came to visit you or stay with you for some period of time is committing nuisance. You are aware that this guest is committing nuisance and you does not stop it. You just continue watching and folding your hands. Then you, as the occupier, you can be sued for nuisance. Now, having said that, let's then move on to the next instance in which an occupier can be sued for nuisance. And that is if the nuisance was created by a trespasser, stranger, presidator in title, tenant, acts of God, and the occupier knows or ought to have known, but adopted or continued the nuisance by failing to take reasonable measures to timeously abate it. So by the time an occupier knows that a third party, now this third party is not his guest, is not his relation, is not his lodger or anybody is related to, but it's just a third party, it's a trespasser. The occupier knows that this trespasser is committing nuisance through in the land that he occupies, and he does not do anything, or he does not timeously, he does not quickly stop it, then the occupier can be liable, then the occupier can be sued for nuisance. Now, let's go to the last category. Let's go to the last instance in which an occupier can be sued for nuisance, and that is if the nuisance existed before the occupier moved in. If the nuisance existed before the occupier moved in, and the occupier knew of it or ought to have known of it but failed to take reasonable steps to abate it. So yes, this nuisance existed before the occupier moved in. This nuisance was in existence before the occupier occupied the land or came into occupation of the land. Now that he have come into occupation of the land, he's supposed to abate it. He ought to have stopped it, but rather instead of stopping the nuisance, he just watch. He just fold his hand and let the nuisance continues. The occupier can be sued, though he met it there, but due to the fact that he turned a blind eye at the nuisance, then the occupier can be sued for nuisance. Then that is it for categories of persons that can be sued for nuisance. But however, you must note this before drawing the content on public nuisance and private nuisance and categories of persons that can sue and be sued. You must note this: where there are several persons responsible for a nuisance. Now, it is not just a single individual that is responsible for the nuisance. There are several persons responsible for this nuisance. Who do you sue? Do you sue everybody, or you just or can you just sue a particular individual? So now let's look at it. When there are several persons responsible for a nuisance, when there are several persons responsible for a nuisance, a plaintiff may sue. A plaintiff may sue one of the joint tortfeasor. A plaintiff may sue one of the joint tortfeasor, and it is not a valid defense for the defendant to show that his singular act did not create all the nuisance. So that's the answer. By the time several persons are responsible for a nuisance, it is not necessary that the plaintiff will sue all the persons that created the nuisance, but it is sufficient that the plaintiff just sue one of the persons that committed the nuisance. And by the time the person is sued, it is not a valid defense for the person to say that I'm not the one that committed all the nuisance. It is me and some other persons that committed the nuisance. I'm not the one that committed all the nuisance. It is not a valid defense. So this is it for public and private nuisance and categories of persons that can sue and be sued. As you all know, by name, I am Japhet Okaka Ibusetali. Thank you so much for watching.